brother is a real estate attorney, has been for 22 years. He knows how to read a title search better than most of the circuit court judges in our county. He knows what an encumbrance is. He knows what a lien is. He knows what a federal designation on a property record means, what it costs, and what happens to the person whose name is on the deed when that designation exists. He has explained all of that, in plain language, to paying clients hundreds of times. He was not careless by accident. He was careless because he had already decided he had won. And those are very different things. His name is Dennis. He's 54. He lives in a suburb of Columbus, Ohio, in a house with a 3-car garage that he mentions about once every time you talk to him. He has a wife named Carla, 2 grown kids I've met maybe 8 times total, and a practice he built from scratch starting in his late 20s. He is genuinely good at his job. I want to be clear about that. Whatever else I tell you, Dennis is a competent attorney. His clients trust him. His referral network is solid. His reviews are good. He charges what he's worth, and he usually delivers. I'm his younger sister. My name doesn't matter for this. What matters is that I'm not an attorney. I didn't go to law school. I didn't go to any school past a community college degree in business administration that I finished in my early 20s and never really used. I spent the first half of my adult life in administrative work, insurance offices, a hospital billing department, a dental practice for 11 years that I actually liked. I was good at details. I was good at paperwork. I was the kind of person who read the fine print because nobody else in my family ever did. And then my mother got sick. That was 2003. She was 61. Her doctor called it early cognitive changes, which is a phrase designed to make something unmanageable sound like a gentle beginning. Within 2 years, she needed help with most daily tasks. Within 4, she didn't reliably know where she was when she woke up. My father was still healthy enough then, and he handled most of it himself for a while. But he was 67 with a history of heart problems, and by 2007, it was clear that the two of them together were more than one retired man with a bad valve could manage alone. I moved in with them in October of 2007. I want to be specific about that date because Dennis will sometimes describe what I did as staying with them for a while. That's his version. I stayed with them. For a while. I want you to keep that framing in mind because it's basically the whole story of what he thought he deserved. I left my apartment in town. I put most of my furniture in storage. I moved into the small bedroom at the back of my parents' house on County Road 14, which is about 45 minutes outside of any city worth naming. And I want to tell you what happened in that house over the next 10 years before I tell you anything about the land, because if I skip it, you'll have the skeleton of the story, but not the weight of it. The first thing I did when I moved in was build a system. I know that sounds administrative and cold, but that's what was required. My mother had been on 3 medications. By the end of 2007, she was on 7. Each had its own dosing schedule, its own contraindications, its own pharmacy, and its own prior authorization cycle with the insurance company. Prior authorization, if you haven't dealt with it, is the process by which an insurance company requires your doctor to submit documentation proving that a medication is medically necessary before they'll agree to pay for it. The authorization expires. Every year, sometimes every 6 months, you start over. You call the doctor's office submits the form. The insurance company loses the form, or denies it on a technicality, or approves a different dosage than the one prescribed. And then you call again. And again. I kept a binder. Actually, I kept 3 binders. One for my mother's medical history, organized by provider and by date, with a section for insurance correspondence. One for my father's, thinner at first, then not. And one for the house itself, property tax records, utility accounts, the HVAC service contract, the well pump warranty, the name and cell number of the man who'd maintained their septic system for 15 years. By 2009, the medical binder for my mother alone was 4 inches thick. I built a spreadsheet for the medication schedule, columns for drug name, dosage, prescribing physician, pharmacy, refill date, prior authorization renewal date, and copay amount. I updated it every time anything changed, and things changed constantly. Doctors adjusted dosages. Insurers changed formularies. A medication that was covered in January was suddenly Tier 3 in April, meaning the copay tripled, meaning I had to call the doctor to request a therapeutic substitution, meaning another prior authorization cycle, meaning another 2 to 3 weeks of back and forth while my mother was taking the wrong dose or no dose at all of something her brain needed. I'm not telling you this for sympathy. I'm telling you because Dennis had a view of what was happening in that house that was constructed entirely from my summaries. He got the edited version. He got the version I gave him during the 20-minute calls he made on Sunday afternoons, when he'd ask how things were going, and I'd say, manageable, because that's what I said. I said, manageable, because saying the alternative would have produced either a solution I didn't want, institutional care, which my parents had explicitly refused and which I had agreed to honor, or nothing at all. And I'd learned early that Dennis's response to complex problems he couldn't solve from a distance was to reframe them as less complex than they were. It was a professional habit. It served him well in commercial real estate. It served him less well as a family member. He never asked about the binders. He never asked about the spreadsheet. He didn't know the spreadsheet existed. What he asked about, on those Sunday calls, was the burn rate. That was his phrase, burn rate. He'd ask, "What's the burn rate looking like this month?" As if we were a startup. As if there were a runway to calculate and a pivot to execute when the numbers got bad. I would give him the honest number. Grocery costs, medication copays, the aide we brought in 3 afternoons a week to give me time to run errands, the physical therapy copay my father started needing in 2009 after his second cardiac event, the cost of the specialty incontinence supplies that Medicare covered partially and then stopped covering when they changed the coding criteria for my mother's diagnosis category. Medicare coding criteria. I want to stay on that for a moment because it matters. My mother had a dementia diagnosis, dementia-related incontinence supplies. Adult briefs, underpads, disposable gloves for the aides are covered under Medicare Part B under specific HCPCS codes. In 2011, Medicare revised the coverage criteria for those codes. The revision required updated physician documentation every 6 months, certifying that the incontinence was directly attributable to a neurological diagnosis and was not otherwise manageable. The documentation had to use specific language. If the physician's note said cognitive decline instead of dementia with neurological impairment, the claim was denied. I know this because in the fall of 2011, we had 3 consecutive months of denied claims while I figured out what the documentation error was. During those 3 months, I was paying out of pocket for supplies that cost approximately $420 a month. I called Medicare's provider line. I called my mother's neurologist's billing office. I found the correct language in the Medicare Benefit Policy Manual, a federal document that runs to several hundred pages and is updated quarterly, and I sent it to the billing coordinator at the neurologist's office in an email with the relevant section highlighted. The coordinator updated the language in the physician notes. The claims were reprocessed. We got a partial reimbursement for 2 of the 3 denied months. I did not tell Dennis about this on the Sunday call. I said, "We had a billing issue with Medicare, but it's resolved." He said, "Good. What's the burn rate looking like?" I told him. He said he'd been thinking about the property and that rural land values in that corridor had been moving, and it might be worth having someone look at it when the time came. Not now, obviously, just something to keep in mind. He said he had contacts who did rural land deals in the region and that he'd make some calls when things settled down. I said, "Okay." He said, "You're doing a great job, by the way." I said, "Thanks, Dennis." He said he had to go. He had dinner with a client. I want to tell you about the aides, because people who haven't managed elder care in a rural area tend to assume it's simpler than it is. We went through a home health agency first. The agency was the right call initially. They handled the hiring, the background checks, the scheduling. They sent us a woman named Francine, who was genuinely skilled with my mother, patient in a way that didn't look performed, and we had her 3 afternoons a week from late 2008 through early 2010. Then, the agency raised their rates. Not by a little. Their per-hour rate went up 22% in one billing cycle, which they attributed to insurance costs and minimum wage adjustments. The combined hours we needed, 3 afternoons, which was approximately 18 hours a week, went from costing us roughly $800 a month to just over $1,000. At the same time, my father's dialysis copays had started, which were running about $360 a month for the sessions and another $140 in transportation-related costs. I did the math on the home equity. My parents had bought the property in 1988 for a number that seems almost fictional now. By 2010, the remaining equity after their mortgage, paid off in 2002, fortunately, was entirely theoretical because the property's resale value in a rural Ohio market was limited and declining, and there was no mechanism to access it without selling, which they weren't going to do. So the equity was real on paper and useless in practice. I left the agency. I found Francine directly. She was willing to work privately at a rate that was better for both of us than the agency arrangement, which she hadn't been happy with either. I handled the taxes. When you hire someone privately as a household employee, you're responsible for payroll taxes, which means a Schedule H on the federal return and registration with the state. I filed those myself. I also found a second aide, a woman named Rosalind who did weekend mornings, through a church bulletin board in the next town over, which is how caregiving support actually gets found in rural counties. Not through agencies, through bulletin boards and word of mouth and knowing who to ask. I had both of their contact information in the house binder. I had a backup contact for each of them in case of illness. I had a written protocol for each aide covering my mother's routine, her behavioral triggers, what to do if she became agitated, who to call if there was a medical concern, and where the medication log was kept. I had trained both of them myself. I'm describing this because I want you to understand the specific texture of what I was doing every day, year after year, in that house. It was not emotional caretaking in the vague sense. It was project management. It was compliance work. It was exactly the kind of detailed, procedural, invisible administrative labor that, if you paid someone to do it professionally, would be billed at a rate that most families couldn't afford. I know what it would cost because I'd spent a decade in medical billing, and I knew what care coordinators charged and what they did. I was doing that job, plus the physical caregiving, plus the property management, plus the financial management, and I was doing it for free, and I was doing it alone, and on Sunday afternoons, I was summarizing it in 20-minute phone calls to a man who asked about the burn rate. Dennis, during those same years, was building his commercial real estate practice. He'd made partner at his firm by 2010. He had 3 significant accounts: an industrial developer, a regional hospital system doing property acquisitions, and a land use consulting group that did work across 5 counties. He talked about those accounts on the Sunday calls when he talked about work, which wasn't often. He talked about deals that had closed, square footage, title complexity, what the zoning variances had cost, and what they'd unlocked. He was proud of that work. He should have been. It was genuinely sophisticated legal work, and he was good at it. Somewhere in that same period, I think it was around 2012, though the exact year blurs slightly, Dennis gave me what he framed as helpful advice about the estate. He called on a Sunday, same as always, and after the burn rate question, he mentioned that he'd been thinking about Medicaid planning. He said it in the careful, informational tone he used when he was explaining something he considered obvious. He said that if either of our parents eventually needed nursing home-level care, Medicaid would require them to spend down their assets before coverage kicked in. He said Ohio had a 5-year look-back period, meaning the state could review and potentially recapture any asset transfers made within 5 years of a Medicaid application. He said the house and the land were probably the only assets worth protecting, and that protecting them meant understanding how ownership was structured and what transfer options were available. I understood what he was telling me. He was telling me what he had already done with his own financial exposure. What he had done, and I pieced this together slowly from the calls, from what he did and didn't volunteer, was legal and straightforward by the letter of the law. He had no ownership interest in my parents' property. His name was not on the deed, had never been on the deed. His finances were entirely separate from theirs. If my parents had needed Medicaid at any point, His assets, his practice earnings, his equity in the Columbus house, his retirement accounts, were untouchable. Ohio's estate recovery program could only pursue assets that had been in the deceased person's estate. Dennis had nothing in their estate. He had made sure of that, structurally, years before any of this became urgent. He was not doing anything wrong. I want to be precise about that. Medicaid planning is legal. Protecting your own assets from a parent's potential long-term care costs is something estate attorneys advise clients to do routinely. He was not obligated to expose himself financially. No one is. What I'm telling you is how it felt to be on the other side of that structure while I was standing in my parents' kitchen at midnight, weighing out medications. He had quarantined himself, cleanly and professionally, and in complete compliance with the law, he had built a legal firewall between his financial life and the slow bankruptcy that was happening in that house. The property was the only asset left to absorb the damage, the declining equity, the unpaid costs, the accumulated drain of a decade and a half of care. If Medicaid had ever come into it, the state's recovery claim would have landed on the house, and on the 60 acres, and on nothing else. Dennis's name was nowhere in that exposure. Mine was, by the simple fact of living there and paying for things, and keeping the property maintained, and making sure there was a house left to recover against. He'd explained the legal mechanics of asset protection to me on a Sunday afternoon in a tone that assumed I'd find it useful. I did find it useful. I found it clarifying in a way he probably hadn't intended. He built his firewall, and I emptied bedpans, and on Sunday afternoons he asked about the burn rate. Once, in 2013, he mentioned in passing that he'd handled a Superfund adjacent title issue for a commercial client. A developer had wanted to acquire land that turned out to carry a federal environmental remediation notation, and Dennis had advised them to walk away and structured the withdrawal in a way that protected the client from liability. He explained the situation briefly. He was clearly pleased with how he'd handled it. He said, "Those environmental encumbrances are basically property death sentences unless the cleanup's already happened and documented. Nobody wants that paper attached to their deal." I remember that conversation. I remember it specifically. I was sitting in the kitchen of the house on County Road 14 when he said it, looking at the field through the window, and I thought about the notation in the county file, the one I'd found 3 years earlier when I pulled the full property record to appeal the tax assessment. And I did not say anything about it. Not because I was strategizing. I wasn't. Not then. I just understood, in that moment, that Dennis had categorized that house and that land as something he would eventually manage, and that his view of management had a specific shape that didn't include complication. I filed that away and went back to what I'd been doing, which was organizing my mother's new prescription pickup schedule after her neurologist had adjusted 2 of her medications. My father died in February of 2017. He was 79. The kidneys had been the slow problem, but in the end, it was his heart. He'd been on dialysis 3 times a week for nearly 2 years by then, and I'd driven him 40 minutes each way on Mondays, Wednesdays, and Fridays for every one of those sessions except 9, when I was sick myself and Rosalind sat with my mother while a neighbor took him. He never complained about the dialysis. He complained about the drive sometimes, the winter roads, but not the dialysis itself. He was a pragmatic man who had decided to keep going as long as going was manageable, and he had managed it until he couldn't. Dennis came for the funeral. He stayed 4 days. He was warm and appropriate, and he gave a short eulogy that was accurate about who our father was. He helped me with the immediate paperwork, the funeral home, the death certificates, the calls to Social Security and Medicare. He was useful in the way that competent people are useful for a defined, bounded task. On the 4th morning, over coffee, he said he'd been thinking about what came next for our mother and for the property, and that he wanted to start having those conversations soon. Not immediately, just soon. I said that made sense. He went back to Columbus. Our mother died 14 months later, in April of 2019, in the bedroom she'd slept in for 31 years. She had stopped eating reliably about 3 weeks before the end. The hospice team came 3 times in the final week. She died at 6 in the morning on a Tuesday while I was sitting in the chair next to her bed. I had my hand on her hand. She was not distressed. She had not known my name in 6 years. I called Dennis at 7:15. He cried briefly and then asked me, with genuine and careful kindness, whether I was okay, and I said I was, and I meant it in the only sense I could mean it by then, which was that I was still standing. Dennis was at the funeral and stayed 3 days. Then he came back 6 days after that. Not in person, by phone. He was warm, as I said. He asked about my sleep, my eating. And then, with the same managing tone he'd used about the burn rate for 12 years, he told me he'd been thinking about the estate and had some ideas about the land. I said that sounded reasonable. I was exhausted in a way that had no name. I'd been filing death certificates and canceling accounts and completing the administrative tale of a death, which is extensive and which nobody warns you about. I was also, without knowing it yet, starting to surface from something I'd been submerged in so long that I didn't know what air felt like. I wasn't strategic in those first weeks. I was just breathing. But I caught the thing in what he said. He'd already talked to his developer contact. He already had a number in mind. An informal estimate, he was careful to say, not an offer, based on what the land might support as a residential subdivision. He had a colleague in Columbus who handled estate transfers efficiently. There were title issues, he mentioned in passing, using the tone of someone explaining traffic patterns to someone who doesn't drive. I asked him what he meant by title issues. He said these things came up with older rural properties. His colleague knew how to handle it. I let that sit for a day. Then I drove to the county recorder's office. I should explain something about who I was by the time I walked into that office. I'd spent 11 years in a dental practice doing insurance documentation and compliance work. Before that, 4 years in a hospital billing department. I knew how government records offices worked. I knew that if something was attached to a property in a county file, it had been there since it was filed, and it was not hidden. It was sitting in the index, attached to the parcel number, waiting for anyone with a file request form and an hour to spend. I'd actually been to that recorder's office before, 3 years earlier, 2016, when the property tax assessment had jumped and I wanted to understand the basis and whether we had grounds to appeal. Standard practice for anyone managing a property. I pulled the full parcel file. All of it, not just the assessment record, because I'm the kind of person who reads the whole document. That was when I first saw the notation. It had been recorded in 1994, a federal EPA entry tied to the parcel, a Superfund adjacent remediation flag placed on the title record when an environmental assessment found that the subsurface on approximately 31 of the property's 60 acres was contaminated with industrial solvent residue, specifically chlorinated solvents, the kind associated with dry cleaning operations. A dry cleaning business had used a corner of that land for chemical waste disposal in the 1970s and early 80s, before current environmental regulations, before my parents bought the property, before any of us were involved. My parents purchased the land in 1988, 4 years after the contamination was initially flagged, and 6 years before the federal notation hit the title record. They almost certainly didn't know. The attorney who handled their purchase may not have run a complete title search. It was a different era for rural land transactions. None of that mattered legally. What mattered legally was that the notation existed, that it had been in the public record since 1994, and that it referenced a federal remediation order with a cleanup cost estimated, at the time of filing, at somewhere between $8 and $12 million. I read that in 2016. I sat with it for a few days. I did some research. EPA remediation records are public. The case history for the contamination was in a federal database, and there were summary documents from the original assessment. I understood what the designation meant. And I want to explain that meaning precisely because federal environmental liability is easy to say and hard to feel. The legal framework is called CERCLA, the Comprehensive Environmental Response, Compensation, and Liability Act. Passed in 1980, it established what lawyers call strict, joint, and several liability for contaminated sites. Strict means the EPA doesn't have to prove you did anything wrong. You don't have to have caused the contamination. You don't have to have known about it when you bought the property. You simply have to hold the deed. That's the entire basis for your liability, the deed. Joint and several means that if multiple parties are responsible, the original polluter, a prior owner, a current owner, the EPA can pursue any one of them for the full cost of remediation. Not their proportional share, all of it. You can seek contribution from the other parties afterward, but first, the EPA collects from whoever has the deepest pockets or the most accessible assets. In the case of a property with a living owner of record, that is the person whose name is on the deed. For the County Road 14 parcel, the original polluter was the dry cleaning operation, which had dissolved as a corporate entity sometime in the mid-'80s. There were no successor assets to pursue. The prior owners, my parents, were both deceased. The current owner of record, as of the June closing, was Dennis. The contamination itself, chlorinated solvents in the subsurface, creates what the EPA terms a long-term site management obligation. Chlorinated solvents in soil don't stay in soil, they migrate. They volatilize into vapor. They reach the water table. The remediation process for that category of contamination requires soil excavation on the affected acreage, groundwater monitoring wells installed at multiple points on the property boundary, quarterly water sampling with lab analysis, vapor intrusion assessments for any structures on the parcel, and a long-term monitoring plan that continues after active remediation is complete. That plan runs for years. The monitoring reports go to the EPA regional office. If the readings exceed threshold levels, the contractor goes back in. The federal oversight doesn't end when the check clears. It ends when the site achieves regulatory closure, which is a formal determination that the contamination has been reduced to acceptable risk levels, a process that, for solvent plumes of this type, can take a decade or more from initiation. The estimated cleanup cost attached to the 1994 notation was $8 to $12 million. That was $1994. The updated estimate, which Dennis's developer obtained when the title search triggered a Phase 1 assessment, was $11 to $17 million. That gap reflects 25 years of regulatory cost increases, updated remediation standards, and the additional migration of the solvent plume into the groundwater. Whoever owned the land owned all of that. The soil sampling, the wells, the quarterly reports, the federal contractor, the EPA regional oversight, the open-ended monitoring obligation that would follow the active cleanup and sit on the title record for years afterward. The deed was not a real estate asset. The deed was a federal work order with a house attached. Dennis signed it in a Columbus conference room on a Tuesday in June. I did not call Dennis to tell him about this. I want to be precise about why. He had told me, in 2013, exactly what he would do with a piece of land carrying that notation. He'd told me it was a property death sentence. He'd advised a commercial client to walk away from a similar situation and had been proud of that advice. He was a real estate attorney of 20-plus years who knew, professionally, that the first step in any property acquisition was a complete title search. That was not obscure knowledge, that was the most basic step. The step so basic that he explained it to clients who'd never bought property before. The step he could have done himself in an afternoon or instructed his colleague to do as a matter of course. The county recorder's files were public. They had been public since 1994. The notation was not hidden. It was in the index, attached to the parcel number, in the building Dennis could have walked into at any point in the 25 years since it was filed. I read the public record. He chose not to. I drove back to the recorder's office the morning after Dennis called to mention the title issues. The notation was still there. The federal remediation order was still active. I sat in the parking lot for 20 minutes. Then I drove home and called an attorney, not Dennis's colleague in Columbus. I found my own, a probate and estate attorney 2 towns over, one-person practice, a receptionist who was apparently also her daughter. I told her the situation. She pulled the county file herself the next morning and called me back by noon. She confirmed what I already understood. Then she said, and I remember this exactly, "Whoever owns this land owns a federal cleanup order. It doesn't matter what they paid for it or how they got it." Then she said she wanted to make sure I understood there was nothing legally improper about proceeding with whatever outcome Dennis was pursuing, without volunteering information that was in a public record that he, as a licensed real estate attorney, was professionally obligated to access himself. I said I understood. I paid her for 2 hours, $260. I never needed to call her again. But I want to tell you what she had done with those 2 hours, because it turned out to matter more than I understood at the time. She hadn't just confirmed the legal landscape, she had structured the closing documents specifically. When Dennis's colleague sent the estate transfer paperwork, she reviewed every line. She noted that Dennis's proposed structure, the property transferring to him outright in exchange for my receiving the liquid assets, included a clause in which I attested that I had no knowledge of material defects in the property beyond those disclosed in the transfer documents. Standard boilerplate language. She struck it. She replaced it with a clause that stated I was transferring my interest as is, without warranty, and that the transferee had been informed that public records pertaining to the property were available at the county recorder's office, and that it was the transferee's responsibility to conduct independent due diligence. Dennis's colleague accepted the modification without comment. He was moving efficiently. Dennis had told him the transfer was clean and to get it done. A small clause adjustment from the other side's counsel wasn't worth slowing things down over. It was also, as it turned out, the sentence that closed every exit. But while I was working out the legal mechanics, Dennis was working out a different set of mechanics entirely. And I want to describe what those look like from where I was standing, because his approach to this process tells you everything about why he made the error he made. Within 10 days of the funeral, I received the first FedEx envelope. It was sent on letterhead from his firm's Columbus office. The envelope was thick, the kind that signals formality, and the document inside was titled, I'm reading from memory, but I'm close. Notice of Fiduciary Expectation and Estate Asset Inventory Request. It outlined, in precise legal language, that as a co-heir to the estate, Dennis was formally requesting a comprehensive accounting of all assets, liabilities, and expenditures related to the property and estate for the preceding 5 years. It cited statute. It had footnotes. It was the kind of document you send to someone you've decided to treat as opposing counsel. I read it twice. I set it on the kitchen counter next to the coffee maker. A second envelope arrived 11 days later. This one was titled, Schedule of Proposed Asset Distribution and Timeline. It laid out, in the same formal language, Dennis's proposed structure for the estate settlement. The property would transfer to him outright, in exchange for which I would receive my proportional share of the liquid estate assets, the savings account, the car, the small investment account, with the understanding that my 16 years of residency constituted a use and occupancy arrangement for which I had received substantial ongoing benefit in the form of housing. Use and occupancy arrangement. I want to sit with that phrase for a moment. I'd been the sole caregiver for both of my parents for a combined period exceeding a decade. I'd managed their medication, their aids, their medical billing disputes, their property taxes, their furnace repairs, their hospice coordination. I'd driven my father to dialysis approximately 300 times. I'd changed wound dressings and learned to operate a hospital-grade suction device during the last months of my mother's life. I'd given up my apartment, my professional trajectory, and somewhere in there, the plausible shape of a different life. And the document that Dennis's firm generated characterized my presence in that house as a housing benefit I'd received. A third envelope came 2 weeks after that. This one was more direct. It outlined a proposed timeline for property vacancy and transfer preparation, and referenced in a footnote that if the estate settlement was not resolved within 90 days, Dennis reserved the right to pursue formal partition action through the county probate court, which would result in a court-ordered sale and division of proceeds, a process he described as less advantageous for both parties, and which I understood to mean, comply voluntarily or I'll use the courts to force it. He sent 3 FedEx letters in 26 days to a sister who had just buried their mother. He was not being cruel exactly. He was being a real estate attorney operating in the only register he knew, formal, procedural, controlled. He'd decided the outcome, and he was managing the process toward it, and he was doing what he always did, treating the situation as a legal transaction and the other party as someone he could outmaneuver on documentation and timeline. He was so focused on the tactical execution, the letters, the language, the procedural pressure, that he'd apparently skipped the step that comes before all of that. The step he'd always done for every client. The step so obvious it barely needed to be called a step. He never ran a title search. He instructed his colleague to move efficiently because Dennis had already told him the transfer was straightforward. And his colleague, who trusted Dennis's assessment, moved efficiently. He did not pull the full county file. He processed a clean estate transfer between two heirs and sent Dennis the deed. The arrogance of it, and I don't use that word to wound, I use it because it's accurate, was that Dennis was so certain he was managing down, so certain he was handling an unsophisticated party who didn't know what he knew, that the idea of basic due diligence didn't register as necessary. He'd won before he'd checked his work. He'd already counted the money before he'd looked at the land. He signed the deed in a Columbus conference room on a Tuesday in June, uncapped the pen the way people do when they've done it 10,000 times, signed his name, shook hands with his colleague, and shook hands with me. I put my copy of the documents in my bag and walked to the elevator. I drove home on the highway with the windows down. It was warm. I thought about the field the way you think about a bill you've already paid. 4 months later, in October, Dennis called. He didn't sound warm this time. He sounded like a man who had just found something and was still in the first stage of understanding what it meant. His developer, the contact he'd been referencing for months, the one whose interest in the subdivision project had driven the entire timeline, had pulled a full title search when they began the site planning work. The EPA notation came up immediately. A Superfund adjacent remediation flag, recorded 1994, referencing a federal cleanup order with an estimated liability, updated to current federal cost standards, of somewhere between $11 and $17 million. The developer had not been pleased. I want to be specific about what happened next, because this is where the story stops being personal and starts being professional, and the professional consequences are worth understanding in their exact shape. The developer Dennis had been working with was not a casual contact. He was a significant client of Dennis's law firm, one of the firm's top 10 revenue relationships, according to what I later pieced together from what Carla mentioned to our cousin and what our cousin mentioned to me. This wasn't a stranger Dennis had introduced to a bad deal. This was a client his firm had a long-standing relationship with, a client whose trust was institutional rather than personal. When the environmental liability surfaced, the developer's own counsel reviewed the transfer paperwork, the timeline, and Dennis's role in the transaction. They found that Dennis had personally vouched for the cleanliness of the title to his colleague. They found that no independent title search had been ordered before the transfer, that Dennis had told his colleague to move efficiently on what he'd characterized as a straightforward estate transfer. They found that Dennis, a licensed real estate attorney with 22 years of practice experience, had transferred a parcel carrying a 9-figure federal environmental liability to himself without conducting the minimum due diligence he routinely required of his own clients. The developer's counsel sent a letter to the firm's managing partners. I don't know the exact contents of that letter, but I know its effect because Carla told our cousin more than she probably should have at Thanksgiving, and our cousin told me. The firm's senior partners convened within a week of receiving it. The conversation they had to have was not a comfortable one. From their position, there were only 2 possible explanations for what Dennis had done. Either he had been catastrophically negligent, a licensed expert in the exact area of law where the error occurred, who had somehow failed to take the most elementary protective step, or he had known about the liability and had attempted to use his insider knowledge to extract value from an asset before disclosing it to a party he was ostensibly working with. Neither explanation was acceptable. The first was incompetence. The second was something closer to fraud against a key client relationship. They did not fire him. I don't know if that was pragmatic or merciful or some combination. What they did was quieter than firing and, in some ways, harder to recover from. Dennis lost the developer account. The firm made clear, in whatever language firms use for these conversations, that his continued representation of that client was no longer tenable. His other major accounts, the hospital system, the land use group, were quietly reassigned to other partners. His corner office, which he'd occupied for 6 years, was reallocated when the firm added a lateral hire in his practice group. He was moved to a smaller interior office on the same floor. He kept his partnership status, technically, but the work that had defined his practice and his billing numbers was gone. Then the bank letter arrived. Dennis had a refinance application in process on his personal home, the house in the Columbus suburb, the one with the 3-car garage. It was routine, a rate improvement he'd been planning for a year. But when the bank's underwriting team ran his personal financial profile, they found the EPA remediation liability attached to the County Road 14 parcel, which was now titled in his name. A federal cleanup obligation with an updated estimate of $11 to $17 million is not a footnote in a personal financial profile. It is the dominant item. The bank declined the application. Not conditionally, declined. His personal credit profile now carried a contingent federal liability that exceeded his net worth, and no conventional lender was going to process a refinance against that background until the land status changed. The land status was not going to change quickly. Federal remediation approval processes for that designation class, and I knew this from the research I'd done in 2016, move at the pace of federal bureaucracies. An approved remediation contractor has to be identified and vetted. A remediation plan has to be submitted to the EPA regional office. The regional office reviews and approves or returns for revision. The remediation itself, for solvent contamination at that scale and depth, takes years. The estimated timeline I'd read in the case documents was between 6 and 12 years from initiation, and initiation hadn't happened yet. Dennis owned a parcel he couldn't sell, couldn't finance against, couldn't develop, and couldn't give away to anyone with access to competent legal counsel. And his name was attached to the federal liability for as long as it took to resolve. He called me in October, as I said. He didn't sound warm. He asked if I had known. I told him I didn't understand the question. He said the property had an EPA remediation order on the title. His developer had found it. The liability estimate was in the range of $11 to $17 million. The land couldn't be used. The bank had declined his refinance. He said his colleague apparently hadn't run a full title search because Dennis had told him the transfer was clean. There was a silence on the phone. I told him I was sorry he was dealing with that. Another silence. He asked again, "Did I know?" I told him the county recorder's files were public records, that I'd done my due diligence on the property over the years as any person managing an estate would do, and that the notation had been in the file when I looked at it. He said, "When did you look at it?" I said, "A few years ago." The silence was longer that time. He said, and I remember this clearly, "You should have told me." I said, "Dennis, you're a real estate attorney. You've been practicing for 22 years. You tell your clients all the time that the first thing you do before any transfer is pull a full title search. You've said that to me specifically more than once when you were explaining your work. I read the public file. You had every opportunity and every professional obligation to do the same thing." He didn't respond to that directly. What he said instead was that this wasn't how family was supposed to work. That family wasn't supposed to have leverage over each other, that I had deliberately withheld information to hurt him. I didn't feel angry. I'd moved past angry a long time ago, years before the closing, years before our mother died, maybe years before our father died. What I felt was closer to recognition. He was describing the situation, withholding information to hurt him, and somehow it hadn't occurred to him, even then, even with the EPA letter in his hand, that there was another version of the same description. That there was a person who had been in that house for 16 years, a person whose labor, time, career, health, and choices had been treated as legally irrelevant. A person who had been delivering information to him for years, not about the land, but about what was happening in that house, and that information had also been treated as unremarkable. Quietly, professionally, by a man who had other things to manage. I said, I didn't withhold anything from a public record, Dennis. He said some other things after that. I let him say them. They weren't interesting. They were the things a person says when they've made a significant professional error and need the error to be someone else's responsibility before they can figure out what to do next. I told him I hoped he was able to work it out. Then I said I had to go, because I did. I had an early shift the next morning. I hung up. That was not the last call. About 6 weeks later, I'd started the new hospital job by then, had been there maybe 3 weeks. Dennis called on a Wednesday evening. No warmth at all this time. He'd retained outside counsel. Not someone at his firm, someone independent, which told me the firm had distanced itself from whatever came next. He said his attorney had reviewed the estate transfer and believed there were grounds for a fraudulent omission claim. That I had known about a material defect in the property and had deliberately concealed it to induce him to accept an asset he would not have accepted had he known the truth. I let him finish. Fraudulent omission, as a legal theory, requires several things. It requires that the party alleged to have concealed information had a duty to disclose it. It requires that the information was not otherwise available to the party claiming harm. It requires that the concealment was intentional. And it requires that the other party suffered damages they would not have suffered had disclosure occurred. I knew my $260 attorney had anticipated this. The duty to disclose element fails first. I had no fiduciary relationship with Dennis in this transaction. We were adverse parties in an estate settlement. He was represented by counsel. I was represented by counsel. Neither party had a legal obligation to volunteer information to the other that was available in the public record. The availability element fails second, and more completely. The EPA notation had been in the county recorder's index since 1994. It was attached to the parcel number in a public database, accessible to any person who walked into that office, or, by 2019, queried the county's online records system. Dennis's own colleague, an attorney whose job was to process the transfer, had access to that file and did not pull it, because Dennis had told him the transfer was clean. Dennis had, in effect, instructed his own representative to skip the step that would have revealed the problem. The information was not concealed. It was sitting in a government office waiting to be looked at. He had chosen not to look. The clause my attorney had inserted into the closing documents, the as-is transfer language, the explicit reference to the county recorder's office as the source of available public records, the transferee's responsibility for independent due diligence. That clause did not just modify the agreement, it created a documented record that I had, in writing, directed him toward the mechanism by which the information could be found. His own attorney signed off on that language. His own colleague accepted it without objection. Dennis had drafted the transfer structure to move quickly. He had bypassed the standard discovery process because he wanted to resolve the estate on his timeline before I could consult counsel or complicate the process. He had told his colleague to skip the title search because he'd already decided the land was clean. Every shortcut he took to push this through faster had stripped away one more layer of the protections that might otherwise have applied to him. He had built a cage of his own procedural shortcuts and then stepped into it and closed the door. His outside counsel apparently reached the same conclusion because the fraudulent omission claim never materialized into a filing. There was no lawsuit. There was no formal demand letter after that call. There was one more call from Dennis about 3 months later, shorter, in which he said something about hoping we could eventually find a way forward. And I said I hoped so too, and we hung up, and I went back to what I'd been doing. I sat at my kitchen table for a while after that first October call. My apartment is small enough that the kitchen table is visible from almost every room. There was nothing on it except a coffee cup and my phone face down on the placemat. It was quiet. October, window cracked, the air smelled like leaves. I'd lived in that family house for 16 years. Before that, I'd visited it almost every week for most of my adult life. For the last several years, I'd managed it entirely alone. I'd left in June and moved into this apartment with its parking lot and its nearby laundromat, and I had not cried about any of it. Not once. I'm not saying that as a point of pride. I think I'd run out of something that would have needed to be there for crying to happen. Whatever that thing is, I used it up somewhere around 2012, somewhere in the third or fourth year of my mother no longer recognizing me, somewhere in the middle of a night when she was calling a name I didn't know, and I made her tea and sat with her, and eventually she went back to sleep. And I went and sat in the kitchen, and the house was very quiet, and I understood, clearly, that I was going to finish this. That I was in it until the end, whatever the end looked like, and I was going to do it alone. And it wasn't going to be acknowledged, and the acknowledgement was no longer something I was waiting for. That was when I became the person who later sat in a conference room and watched her brother sign a deed without flinching. He still owns the land. The remediation estimate came back at the higher end of the range. He's been in contact with an environmental consultant. The land can't be financed, can't be subdivided, can't be sold until the remediation is done. The remediation can't start without a federally approved contractor, and federal approval processes for that designation class move at the pace of federal approval processes. I don't know what Dennis tells his clients when they ask how his own real estate holdings are doing. I imagine he doesn't bring it up. What I know is that I go to work. I have the hospital job, which I'm good at, which doesn't require me to drive 45 minutes in any direction, which ends at 5 o'clock and stays there. I have a small apartment with no furniture that carries memories I didn't choose. I have neighbors I say hello to in the parking lot. I have a television and a coffee maker that works. I don't have the land. I never really had it. Not in the way that would have mattered. The land had me for 16 years. My time, my labor, my presence. And then I gave it back. I gave it to the person who wanted it most and understood it least. And now it has him. That's not a victory. Nothing that happened is a victory. My parents are gone. The years I spent in that house are gone. The version of my life I might have built is gone. Dennis has a parcel he can't use, a professional embarrassment he can't fully explain, and a sister who doesn't answer on the first call. What I have is simpler than a victory. No obligation attached to my name. No mandate to answer for. No field sitting 60 acres wide in a rural county with $11 million of federal liability underneath it. I have a coffee cup on a kitchen table. The window faces east. I go to sleep when I'm tired. That's enough.